morning. Welcome to the current affairs discussion. So the first topic that we'll take is the blanket protest and the legal remedy available to the gig workers. So with the change in the working condition, a new group of workers have come to the market, not only in India but around the world. Fine. They are a completely new group of workers and they are called as the gig workers. Okay, so they are called as the gig workers. Okay, the recent strike in the Zomato-owned bulk delivery agent have once again brought to the forefront the issue of logging the gig economy in the country and the reforms required to stop the exploitation of such workers. Okay, the strike began when the Blinkit rolled out its new payment structure for delivery executives. Under the minimum payout for delivery was slashed from 15 per delivery from 25. Earlier, per delivery, they were receiving, the delivery boy by receiving 25, but right now they will receive only 15 per delivery. Okay, this is a reduction, and this reduction is being opposed by the delivery workers, the delivery boys and girls, called the gig workers. The revised structure also best incentive on the distance covered to execute the order, a policy commonly known as the effort-based pay. As a result, the Blinkit delivery executive are now set to earn 6 to 700 a day as opposed to 1200 on an average per day that they are earning earlier. It will reduce by half to 6 to 700. Earlier, these were receiving around 1200 per day. Okay, so the receipt Niti Aayog estimate, 2020 report by Niti Aayog estimate that nearly 2.3 million workers will be engaged in the gig economy by 2029. However, since the gig economy fall outside the scope of traditional full-time employment, gig workers are usually not afforded basic employment rights such as minimum wage, overtime pay, medical leave. What is available to the regular worker is not available to the gig workers because they are not as they are not regular workers, so the regular things are not available to them. Okay. 23 million workers will be engaged in the gig economy 2020. However, since the gig economy falls outside the scope of the traditional full-time employment, gig workers are usually not affordable basis employee rights such as minimum wages, overtime pay, medical leave, and a statutory bond resolution for employer-employee disputes. Fine. Who is a gig worker and what is platform work? Gig workers refer to workers outside the traditional employer-employee relationship. Okay. There are two group of gig workers: platform workers, non-platform workers. Okay. When gig workers use online algorithmic matching platforms or apps, okay, platform or app to connect with customers, they are called platform workers. So, go no? ସେ ଯୋଉ ମାନେ କ୍ୟାନ୍ସର ପେସେଣ୍ଟ then back to your last grade. So, ଆସନ୍ତୁ କେବେ କରିବେ କାରଣ କେବେ ଆସିଲେ କରିବେ ଏବେ ନେକ୍ସଟ ଆପଣ ଟେଷ୍ଟ ହେଇଯାଏ କାଟିଦେଲା ମାନେ ଅସୁବିଧା ହବ ନା ମାଲିଗ୍ନାଣ୍ଟ କି ନାହିଁ ଜଣା ପଡ଼ିବ ତା ଆଗରୁ ଜଣା ପଡ଼ିବ ହଁ ସେ ନେକ୍ସଟ ଟାଇମ ଆସନ୍ତୁ କରିବେ ଯିବେ okay. So when the gig worker use online automatic matching platform or app to connect with customers like the Ola, Uber, Swiggy, Zomato, they're called platform workers. Those who work outside these platforms are non-platform workers, including construction workers and non-technology based temporary workers. Whether gig workers should be categorized as employers or as independent contractor has been a frequent debate across different jurisdictions, means different countries. The test to determine whether a worker is an employee or an independent contractor depends on the extent of control and supervision exercise. Okay. The test determines whether a worker is an employee or an independent contractor depends on the extent of control and supervision exercised by the employer and the integration of the worker with the organization. Right? In India, employees are entitled to a host of benefits under statutes such as the Minimum Wage Act 1948, Employees Provident Fund and Miscellaneous Provision Act 1952, and the Payment of Bonus Act 1965. Similarly, contract laborers are governed under the Contract Labor Regulations and Abolition Act 1970 and are also entitled to benefits such as Provident Fund in accordance with the Employee Provident Fund Act. Okay. Okay. However, given the unique nature of gig workers display characteristics of both employee and independent contractors and thus do not squarely fit into any rigid categorization. As a result, gig workers have limited recognitions under current employment law and thus fall outside the ambit of statutory benefits. What is proposed law for gig workers? In keeping with the National Commission on Labour recommendations to consolidate central labour law, the Ministry of Labour and Employment introduced the Code on Social Security 2020, which brings gig workers within the ambit of labour laws for the first time. Under Section 235 of the Code, a gig worker is defined as a person who performs work or participates in a work arrangement and earn from such activities outside a traditional employer-employee relationship. Okay. The code defines okay platform workers as a worker and work arrangement outside a traditional employer-employee relationship in which organizations or individuals use an online platform to access other organization or individual to solve specific problem or to provide specific services in exchange for payment. Further activities can be added to this list via a central government notification. Okay, although the code recognizes gig workers including platform workers, it distinguishes between such workers and employees. While employees have benefits such as gratuity, employee compensation, insurance, provident fund and maternity benefit, the code only stipulates that central and state government must frame suitable social security schemes for gig workers on matters relating to okay on related to health and maternity benefit, old age securities normally. So these are the benefit with the normal worker get under different acts, but health and maternity benefit, old age security, education, provident fund, accident benefit, life insurance, disability insurance, etc. Normally, the normal workers get this benefit when they work, but these things are not available to the gig workers. Okay, the central government has also been tasked with establishing a social security fund for gig workers. Gig employees must contribute 1.2% of their annual turnover to this fund, which may be used for the aforementioned schemes. Okay. The central government has also been tasked with establishing a social security fund for gig workers. Gig employees must contribute 1 to 2% of their annual turnover to this fund, which may be used for the aforesaid schemes. The code also mandates the compulsory registration of all gig workers to avail of benefits under these schemes. The code also envisages the constitution of a National Social Security Board. What? So, a National Social Security Board by the central government to monitor the implementation of such schemes. What are some of the concern? Okay. Okay, out of the four new labor code proposed, gig work finds reference only in the code on social security. As a result, gig workers remain excluded from the vital benefits and protections offered by other codes such as minimum wages, occupational safety. So recently, government has brought four new codes. One is the minimum wages, occupational safety, health benefits, and overtime pay, and code on social security. The gig workers are only covered on the code on social security, but on others, they have not yet been covered. Okay. They cannot create legally recognized unions on access in national minimum wage and apply to all forms of employment. The gig workers, so they are not allowed these benefits. Okay. They cannot create legal recognized union and access national minimum wage that apply to all forms of employment. According to analysts, even the proposed law does not guarantee minimum wages for gig workers. Minimum wages, which is presently governed by the Minimum Wage Act, will be subsumed under the wage code, and the wage code again is only looking to protect those who fall under the traditional employer-employee relationship. Okay. As of today, there is nothing to protect the minimum wage of a gig worker unless and until one can provide that. Okay. As of today, there is nothing to protect the minimum wage of a gig worker unless and until one can prove that the gig worker is actually an employee, and that could be a challenge when engagement are structured in a way to ensure that one stays outside an employer-employee relationship. Fine. This is a big issue, challenging one, because in future their number is going to increase substantially. Okay. Gig workers also remain excluded from accessing the special redressal mechanism under the Industrial Dispute Act 1947. Okay. Gig workers remain excluded from accessing the specialized redressal mechanism under the Industrial Dispute Act 1947, thus denying them an effective remedy for grievances against their employers. Considering the non-traditional nature of their work, gig workers also do not have the right to collective bargaining, a fundamental principle of modern labor law, crucial to safeguarding the rights of workers given the skewed bargaining power between employer and the employees. However, Okay. However, despite receiving the assent of the President, the Labour Code are still awaiting implementation 3 years on. Okay. The centre has said that this is due to the delay in framing of the rules by the state. According to central government, in 2023, only a few states have not yet framed the rules. In 2022, okay, report by Fair Work India International Research Project, okay, highlighted the deplorable working conditions of the employees of digital labor platforms in India and the need for statutory affirmation of the rights of gig workers. With the gig industry gaining prominence across the world and legislation being passed to that effect over the above social security benefits, it is possible to expect continuing challenges brought about by gig workers to protect their rights until the law is amended to protect their interests. Can judicial intervention be expected? In September 2021, the Indian Federation of Up-Based Transport Workers filed a public interest litigation on behalf of a gig worker before the Supreme Court. The petition demanded that gig workers or platform workers. Okay, it has been contended that the exclusion of gig workers from the category of unorganized workers. Okay. It has been argued that it has been contended that the exclusion of gig workers from the category of unorganized workers or wage workers under section 2 M and 2N of the Act called the Unorganized Workers Social Security Act is violative of the fundamental rights under Article 14 and 20 of the Constitution. It has been argued that such denial, okay, of social benefit amounts to exploitation through forced labor within the meaning of Article 23. Although the Supreme Court sought the centre's response to this petition back in December 2021, the centre has not filed any response yet, not further hearing has taken place either. But an international court held. Okay. In 2021, in a landmark judgment, the UK Supreme Court classified Uber drivers as workers under UK Employment Right Act 1996. Thus, okay. The Dutch High Court also handed down a similar ruling stating that the legal relationship between the Uber and the drivers meet all the characteristics of an employment contract, making them entitled to workers' right under the local labor law. In August 2021, the Superior Court of California and USA struck down 2020 bailout measure known as Proposition 2022 that excluded gig workers. Okay. So in UK, in Denmark, in USA, Germany Temporary Employee Act provides for equal pay and equal treatment to gig workers. Further, Singapore has also proposed legislative changes to extend work injury insurance and pension coverage to such workers. That means around the world. So the gig workers are right now being recognized. Okay. Okay. Supreme Court power under Article 42. The next topic is regarding judicial activism. So, context: a five-judge or constitutional bench of the Supreme Court on May 1st held that a court can directly grant divorce under Article 142 of the Constitution in case where the marriage has irretrievably broken down without referring. Okay. Okay. Without referring the parties to a family court first, where they must wait for 6 to 18 months for a decree of divorce by mutual consent. That is Article 142 of the Constitution. Article 142 provides a unique power to the Supreme Court to do complete justice between the parties, where at times the law or statute may not provide a remedy. In this situation, the court can extend itself to put an end to dispute in a manner that could fit the fact of the case. How have court exercised this power? While the power under 142 are sweeping in nature, the Supreme Court has defined. Okay. The Supreme Court has defined, okay, its scope and extent to the judgment over time. In the Premchand Garg case, the majority opinion, okay, demarcated the contours of the exercise of the court's power under Article 142(1) by saying that in order to do completely, okay. So by saying that in order to do complete justice between the parties must not only be consistent with the fundamental rights guaranteed by the Constitution, but it cannot even be inconsistent with the substantive provisions of the relevant statutory law. Referring to law made by Parliament, Supreme Court added, therefore, we do not think it could be possible to hold that Article 142(1). Okay. Okay. So the seven judge bench in Antulya upheld the 1962 ruling of the Premchand Garg, notably in the Bhopal gas tragedy case, the Indian Carbide case. The Supreme Court in 1919 ordered Indian Carbide to pay $470 million compensation for the victim of the tragedy. In doing so, the bench highlighted the wide scope of Article 142(1), adding that it found it necessary to addressed certain misconceptions in the argument touching the scope of the power of the court under Article 142(1) of the Constitution. Deeming the power under Article 142 to be an entirely different level and of a different quality, the court clarified. Okay, okay. The sweeping nature of this power has invested the criticism that they are arbitrary and ambiguous. It is further argued that the court then has wide discretion and this allows the possibility of its arbitrary exercise. Okay. Defining complete justice is a subjective exercise that differs in its interpretation from case to case. Thus, the court has to place check on itself. Okay. In 1998, the Apex Court in Supreme Court Bar Association version of India held that the powers under Article 142 are supplementary in nature and could not be used to supplant or override a substantive law and build a new edifice where none existed earlier. The court said that the power conferred by Article 142 are curative and cannot. Okay, so that more recently in its 2006 ruling in a Jindarnath versus Jubilee Hills Cooperative Housing Building Society, the Supreme Court discussed the scope. Okay, to catch a person not party to the case. Okay, okay. Another criticism of the power under Article 142 is that, unlike the legislature and the executive, the judiciary cannot be held accountable for this action. The power has been criticized on ground of the separation of power doctrine. We say that the judiciary should, okay, not venture into areas of lawmaking and that it would invite the possibility of judicial overreach. However, the drafting committee of the Indian Constitution was mindful of the wide-reaching nature. Okay, okay. Additionally, the apex court has Additionally, the apex court has imposed check on its own power under Article 142 in 2006, and the Supreme Court ruling by a five-judge bench in the state of Karnataka versus Umandevi also clarified that complete justice under Article 142 means justice according to law and not sympathy, while holding that it will not grant a relief. The apex court has imposed check on its own power under Article 142 in 2006. The Supreme Court ruling by a five-judge bench, state of Karnataka versus Madhavi also clarified that complete justice under Article 142 means justice according to law and not sympathy, while holding that it will not grant a relief which could amount to perpetuating an illegality. Okay, encroaching into the legislative domain. Okay, then the National SCST HOP scheme, another one. PM appreciates success of National SCST HOP scheme. The National SCST HOP would provide professional support to the SCST enterprises, enabling them to effectively participate in public procurement process. The hub would also work towards the development of new entrepreneurs to participate in procurement process, leveraging on the Stand Up India program. Okay, okay. The hub would also work towards the development of new entrepreneurs to participate in procurement process, leveraging on the Stand Up India program. Selected entrepreneurs would be provided with support and mentoring by industry experts, central public sector enterprises, and incubators. The hub could operate out of the National Small Industries Corporation headquartered in Delhi. Administrative structure: High Power Monitoring Committee. Okay. Minister of MSME is the chairperson of the committee. The committee member and plenty of the various stakeholders, including states, various ministry, industry association, and SCST entrepreneurs. Advisory committee. This committee should work under the High Power Monitoring Committee in order to bring the industry and SCST entrepreneurs perspective to the hub. Purpose: developing an effective mutual beneficial relationship between the target group and the government. Okay. That is what. Okay.
OES student guest है ना OES
Interview देगी.
ना ना नहीं नहीं पे दब्बा
So lunch for. Okay. This committee could work under the High Power Monitoring Committee in order to bring the industry and SC/ST entrepreneurs perspective to the house. Okay. Okay. So this committee would work under the High Power Monitoring Committee in order to bring the industry and SC/ST entrepreneurs prescribed to the house. Purpose: developing an effective mutually beneficial relationship between the target group and the government. Empower Project Approval Committee. This committee would ensure flexibility with a view to accommodate changing requirement of SC/ST entrepreneurs. Then the next topic is Asian India Maritime Exercise. Indian naval ship Satpura and Delhi with RA team Rear Admiral Gurcharan Singh, the flag officer commanding Eastern Fleet, embarked on board, arrived at Singapore on 1st May 2023 to participate in the inaugural Asian India Maritime Exercise scheduled from 2nd to 8th May 2023. The harbour phase of the exercise is scheduled to be held in Changi Naval Base from 2nd to 4th March 2023, and the sea phase will be conducted from 7th to 8th May 2023 in the South China Sea. MI 2023 will provide an opportunity for the Indian Navy and the Asian Navy to work together closely and conduct seamless operations in the maritime domain. INS Delhi, India's first indigenously built guided missile destroyer, and INS Satpura, an indigenously built guided missile stealth fighter, are the part of the Indian Navy Eastern Fleet based on Visakhapatnam and function under the operational command of the flag officer commanding in chief Eastern Naval Command. These ships are fitted with state-of-the-art weapons and sensors. The ships during the port call at Singapore will also participate in International Maritime Defense Exhibition, INDEM 23, and International Maritime Security Conference (IMSC) being hosted by Singapore. Then the PMJY, the African swine fever, the livestock illness that has decimated porcine populations across Asia since its advent in China in 2018, would deal a lethal blow to the pygmy hawk and the world's rarest, the smallest pig. It is extremely susceptible to extinctions from SF due to its small population and limited range. Scientific name: the Purpura salvinia. The pygmy hawk is the smallest and rarest winged swan in the world. The species was historically known from only a few locations in northeast West Bengal and northwestern Assam in India, though it is now believed likely to have occurred in an extensive area of tall alluvial grassland south of Himalayan footing from northwestern Uttar Pradesh and southern Nepal to Assam, possibly as far as southern Bhutan. At least 2 decades without reported sighting of the species was already feared extinct. It is called almost extinct. Pygmy hawk. However, in 1971, it was coincidentally discovered in 2 separate locations in northwestern Assam, namely Barani Reserve Forest in Darang district and the Manas National Park. The pygmy hawks prefer undistributed patches of grassland dominated by early successful riverine community, typically comprising dense tall grass intermixed with a wide range of house, scups, and young trees. The species is not found in areas subject to prolonged inundation during the monsoon. Pygmy hawks feed on roots, tubers, shoots, and Okay. So the species not found in areas subject to prolonged inundation during the monsoon. Pygmy hawks feeds on root, tuber, shoots and ground vegetations along with worms and other invertebrates and probably small vertebrates, reptiles and eggs and nestling of the ground nesting birds. Status of conservation: the IUCN has listed pygmy hawks as a critically endangered. It is also listed in the Schedule 1 of the Indian Wildlife Protection Act 1972. The main threat to survival of pygmy hawks are loss of degradation of habitat due to human settlements, agricultural encroachment, flood control schemes, and traditional forest management practices. Small farm management practices such as planting a tree in the grassland and indiscriminate use of fire to create opening and to promote fresh growth of grass have caused extensive damage to the habitat of the authority intended to protect. But is African swine fever? African swine fever is a highly contagious viral disease of domestic and wild pigs whose mortality rate can reach 100%. It is not a danger to human health, but it has devastating effect on pig population and the farming economy. There is currently no effective vaccine against this African swine flu. The virus is highly resistant in the environment, meaning that it can survive on cloth, wood, switch, and other materials. It can also survive with the various food products such as ham, sausage, and bacon. Several countries have protected ASF projects since 2005 as of 2022. In January 2022, the SF genotype 2 was notified on the Italian mainland after around 40 years of absence. Two new countries reported the first occurrence of the disease in January as well: North Macedonia and Thailand. Okay. Question: Progress on achieving a sustainable development goals seem to be slowing down in India. Examine the hindrances in the country in attaining the SDG targets. The Sustainable Development Goal framework set target for 231 unique indicators across 17 goals related to economic development, social welfare, and environmental sustainability to be met by 2030. A study covering 9 SDG held at the India is on target to meet certain indicators or neonatal and under 5 mortality, full vaccinations, and electricity access. However, certain SDG indicators related to women well-being and gender inequality, etc., paint a worrying picture. Also, the progress on these targets doesn't apply equally to the district in the country because SDG goals are set by UNGA for 2015 to 2030. 17 goals are there. So, hindrances faced by the country in achieving SDG targets, bottlenecks in the localization of SDG, the process of policy. Okay. The process of policy and budget making, planning and implementation is not clearly reflecting SDG at the level of state and local government. Further, the devolution of funds, function of functionaries to local government is still not achieved in most of the states. Hence, local government, both rural and urban, are not able to prepare people's plan and local budget for their respective area through people's participation. Issues of implementing strategy like VANIK-IAS, the state planning department, boards in the state have also been made nodal agency to oversee the process of implementation of the SDG at the state level. So far, many states are not prepared for the implementation of the SDG given their capacity in terms of adequacy of financial and human resources and decentralized planning process followed by them. Financing SDG, India requires $170 billion per year from 2015 to 2030 to fulfill the SDG targets. Investment are particularly required towards achieving SDG 3, 4, good health and well-being and quality education. Challenges in achieving gender equality. The SDG 5, which stands for gender equality, has been the toughest to fight and establish in India. According to study, India will not meet the SDG on gender equality by as late as 2019. The difficulty in achieving gender equality lies more in the implementation of law and schemes and breaking the cultural and patriarchal nut that exist within the country. Challenges created by the pandemic. All the 17 SDG are interlinked, and the impact of one can derail the efforts to achieve the other SDG. The pandemic has affected health and well-being, pushed millions into poverty, leading to a rise in inequality. COVID has also led to worsening of the education inequality. Issue in the monitoring of the SDG. Monitoring of outcomes has been one of the major challenges under the SDG due to the lack of preparation of developmental indicators at state, district, and block level. The framework of monitoring and tracking the development benefits adopted at the center level also lack focus on the inclusion of marginalized communities, even though social inclusion one of the three pillars of SDG. Okay. Okay. So, way forward, enhancing financial resources, the focus should be on increasing the budgetary allocation for low performing indicators, or SDGs, such as health, education, and gender equality. Building political will, the focus should be on creating strong and sustained political leadership supported by a responsive administrative structure at all levels, from the national to the district level. Data-driven approach, India must put in place a coordinate public data platform by consolidating its many soiled platforms into an integrated digital resource for district administrator as well as state and national policymakers. Preparing a decadal plan, there is a need to innovate a new policy path by taking a time-driven approach. Preparing a decadal plan for SDG indicators should help in proper monitoring and targeting. Linking existing government schemes to SDG in the current policy landscape, there are existing programs and framework in place that can be linked to the indicator of SDG. For example, programs such as Pradhan Mantri Awas Yojana, the Ujala Yojana 2.0, and the Jal Jeevan Mission are all relevant to SDG 1 when poverty knowledge forms everywhere. India's commitment to the SDG is reflected in its convergence with the National Development Agenda, as reflected in the motto of Sabka Sath Sabka Vikas. To succeed in meeting the SDG targets, especially those related to population health and well-being, basic quality infrastructure, and gender equality, nationwide effort should be need of the hour. Then coming to the MCQs of discussion. When the following statement regarding the gig economy, China and the United States are the top two ranked country with the highest number of gig workers. That is right. It's in India. It is not okay. At present, which is not correct. One is not correct. At present, more than 50% of the new employment in India generated by the is right. Social code on social security 22 aims to provide labor rights to gig workers. No, 1 and 3 are incorrect. Answer is she. Following statement about African swine fever is highly contagious, so it is right. It can affect both domestic and feral pigs, right? It can cause fever and blood clotting in humans. No, no human transmission. 1 and 2. With reference to pygmy hawks, consider the following. It is an indicator species. Presence reflect the health of the primary habitat, tall and wet grassland. That is right. It is protected under the same schedule of Wildlife Protection Act 1972. The only viable population in the wild is in Manas Tiger Reserve, Assam. 1, 2, 3, all are correct. With reference to Constitution of India, prohibitions, supplementations, or provisions contained in ordinary law cannot act as a prohibition on limitation on the constitutional powers under Article 142. It could mean which one is of the following. The decision taken by the Election Commission of India while discharging duty cannot be challenged in any court of law. That is, that it does not mean. The Supreme Court of India is not constrained in exercise its power by law made by the Parliament. That is right. B. Then, with reference to National SCST Hub, it is an initiative of Ministry of Micro, Small, Medium Enterprises. That is right. It is applicable to Greenfield SC entrepreneur startup only. No, all Greenfield, Brownfield, all one is correct. Which of the following Navy or sea participated in Asian India Maritime Exercise? INS Delhi participated and INS Satpura participated. So 1 and 4. D. Then which of the following are the considered the laundromat countries? India, China, United America, Singapore, Turkey. It is all the 5. Okay. The West tax intermediate sometimes found news related to it is on crude oil. The Forest Right Act 2006 provides a legal framework for converting all forest on surveyed villages or habitations in forest land into revenue villages. Under this act, Gramin Sabha is authorized to initiate the process of determining the venue, nature and extent of individual or community forest right or both. So 9, it is both 1 and 2 are correct. And 10, Ajjangar Tiger Reserve, it is in Chhattisgarh. So thank you for watching. Keep watching every day on a daily basis to update yourself on the development. Thank you.